Hi guys, how are you? How are you, Chris? How are you, Rupert and Chip?
Good, Rebecca. How you
Hi,
doing?
Rebecca. Very well, thanks. How are you?
Yeah, I'm good. I'm good. Well, Chip, I am so upset that you went all the way down to Australia and Singapore and you did not take me with you to carry your bags. And I thought we were friends.
I think you'll be even more upset when I'm on an island with these guys next week without you. But
Okay, I don't want to know.
fine.
I don't know. That's just so unfair.
It's getting too
Sorry.
hot there now, Rebecca. Anyway, you don't want to be down here.
Well, I've been sitting in the hail all day here, so in England, so not great. But I mean, tell us about this trip because I think you talked quite a lot about the restructuring officer regime in the Cayman Islands, and obviously we've done these other podcasts. So we've looked at the application in different countries. We've looked at what it was all about. So this is 6 months down the line. What are we hearing and what are we seeing?
Yeah, so the trip was through Singapore and Sydney, catching up with some of the INSOL folks, the ARITA and TMA folks, the HLB folks that work in the cross-border restructuring troubled business space. A lot of interaction around what's going on. I think Australia is probably maybe leading the league right now in terms of some trouble starting up and starting to see problems that we've all been prognosticating for a while. So a lot of really keen interest in what's going on here. So much of the Asian Pacific money has ended up coming through this part of the world, going into Cayman, such a huge banking center that money flows through, doesn't stay in so much. And so a lot of interest in what this new arrow in the quiver looks like. They've known that it's come out, not a lot of precedent. And so really that kind of brings us to the reason for the season here today, having the couple fellows who've actually gone ahead and successfully worked their way through the process. And I think specifically involving at least one Asia Pacific joint liquidation type scenario, if I'm remembering right.
Yeah, well, I'm sure they can tell us about the uses. So come on, Rupert, tell us about it. What have you been up to?
Well, we've had two cases so far under the regime, each of which demonstrate how different ways in which it can actually work. The first case was a case called Oriente. That was obviously an Asian-based one that Chip just alluded to a minute ago. And it was more designed to be a standalone restructuring that was going to be done, out of the Cayman Islands in a sort of all singing, all dancing type of way. So that at the end of the day, it was going to be proposed that some sort of scheme or some sort of plan be put to creditors for approval, or something along those lines. Anyway, the second case that I've been involved in with Chris is a case called Rockley Photonics. It was a case that, as I say, demonstrates the other side of the restructuring officer regime, which is to support a foreign proceeding. In the Rockley Photonics case, we had a Chapter 11 proceeding, and then we had a filing in Cayman, which provided for the moratorium here in Cayman, and so to prevent proceedings being pursued in Cayman against the company, in order for restructuring to be pursued in the United States, and then be then implemented to the extent necessary in Cayman.
So that's a very nice, succinct overview. But what I'd really like from you guys is to dish the dirt, basically. Come on, tell us how the scheme's gone. What's it been like? Has it worked in your view? Have there been any surprises for you?
Maybe to jump in. So I was one of the ROs on the Rockley Photonics case, and I think, just to kind of take a step back. So where we started obviously was with the provisional liquidation scheme. I think you've spoken to your audience before about what was wrong with that scheme and why we needed to move towards the RO scheme. So this has been something that we've been looking for on the IP side for a couple of years in Cayman, and I think something that we really needed. Did it throw up any surprises? I actually don't think it did. I think it really worked very smoothly, and I think a large part of that was, and this isn't not trying to curry favor, but I actually think that the Cayman court and the Chief Justice really embraced what we were trying to achieve. And as Rupert said, Rockley Photonics was really trying to was to facilitate a US restructuring. So the main operations, the base, most of the staff, they were all based in the US. So it was a Chapter 11, and if we were kind of in the old regime, filing a winding up petition in Cayman could have been disastrous. So we really needed to have this new regime, this new process. And I think the bells and the whistles, the director has been able to take the lead in terms of filing the petition. The professionals, and particularly on the IP side. So we normally don't get to come in until the date we're appointed. We, getting involved in the planning, the negotiation, dealing with the creditors, kind of developing the actual restructuring plan, that would conflict you out under the kind of old process. So in this situation, we got involved in September. We were working with the company, we were working with the creditors. So we don't actually take the oral appointment until September 2022, get involved, and then February 23 take the appointment. So we've got a kind of a 6-month period where we get to know all the note holders, we get to know the individuals involved, we understand what exactly they're looking for. We work with the company, we get to know the board, we understand what's going to work for this business, what's going to be catastrophic. So this is a company that's it's developing some fairly highly specialized technology. It's very cash intensive, so it's all in development stage, so it doesn't have much of revenue. So it's really reliant on its note holders for kind of ongoing support. So we learn all of this throughout the 6 months. We look at would a sale work here, would raising of external capital work, and we look at what is optimum here, what do the note holders want, and being involved in all of that, I found personally was such a benefit for when we get to the point of here is the restructuring plan, and me as the IP or as the RO, I'm presenting that to the Cayman court and saying, I think this is in the best interest of the company and its creditors and stakeholders. I request that the court approves this, and it was a nice change of pace, I think, for me to be involved in the drafting of that. And I knew for certain when people said, okay, a sale is not a good idea, external financing is not going to work, I knew for certain because I was involved in those discussions, which for me, I think that was one of the real key changes, is that you develop a plan rather than being in most scenarios you're kind of handed a plan, it's a fait accompli, and it's you kind of kick the tires, you speak to some creditors, but at that point everybody's been through a long process, they've been through negotiations, they kind of just want to get it done. So I found that to be I think probably the best or the best change, and the most favorable part about this is like we really understood the plan when it came to presenting it to the court, or when it was presented to us. Essentially we had been involved in it. So I thought that was a really good change.
Yeah, that's good. And Rupert, I mean, do you feel that participation was really helpful in the same way that Chris does? Do you agree with Chris's views, or is there anything else you want to add?
Absolutely. I mean, on the legal side, often you're a little bit more involved. Sometimes you're already acting for the creditors or for the company beforehand. So, and when a provisional liquidator was appointed, you then take on the role as acting for the provisional liquidator. So, from a legal side of things, we probably had more insight into it than what the provisional liquidators have. Now, what we have, I think, is under the restructuring officer regime is really enhanced. It really enhanced matters by allowing for this sort of pre-involvement of restructuring officers in the entire case, and there being specific provisions in the rules to allow for that to happen, which I think has really enhanced things. I mean, the other thing that's really enhanced matters is the fact that we're now sort of analogous with the Chapter 11. You get the moratorium upon filing, and that makes a big difference, I think. Now, I mean, we still are different to the bankruptcy regime in the US, in the sense that, particularly in terms of Chapter 11, that we still have to have a hearing for the appointment of the restructuring officer after the filing. But the bottom line is we have the benefit of the moratorium from the filing now, which is a huge step forward for us, rather than having to file a proceeding and then have a hearing and wait for the moratorium to then be put in place, which could take a number of days, in which time there could be steps taken by creditors to thwart the process being undertaken by the company.
So can I ask you also about the drafting of the restructuring officer appointment and how that worked out, and whether you were able to customize it? How did that work?
It was the order was very heavily tailored. It took some time to draft. You need to list out the powers, and the way that the judges want it done is they want the powers listed out very specifically, down to operating bank accounts, down to all sorts of treatment of assets and things like that. So where it was more broader was perhaps allowing for the negotiation of a plan that allowed for a sort of a more broader power, but many of them were very specific and tailored. And in both hearings, in Oriente and in Rockley, which Walkers was both involved in both of those, we spent some time going through with the judge to determine what precisely the powers were required, because as you can imagine, you might go in there with a wish list, but the judges will drill down on those with you to make sure that there are actual powers that are required.
So
Sorry, just on that point, I mean, I do think that, whilst there was, it certainly wasn't just a kind of a blanket granting of everything that we wanted. There was still a lot of the kind of, I think, carryover from the old PL regime, where you did have, relatively broad powers. So, supervision of the board. So there was enough there to allow us to do our jobs, but not to be interfering with the board day to day. But, the board understood very clearly its, requirements to report to us, to share information with us. So, we felt like we had a good grasp of what was going on. We had sufficient authority. We had enough power and oversight to do what we needed to do, without kind of interfering with the day to day. So I was very happy with how the order panned out.
right, so I mean, it does sound like a US receivership order, and it also sounds like it would allow for more easily to be recognised in model law jurisdictions if needed. I mean, Chip, do you have any thoughts on what the guys have been talking about?
Yeah, lots of good stuff. I think hearing Chris talk about how heavily involved the company and the directors were ahead of time, big difference, big change. I think going to be super well received. So often seems like during winding up appointments, there's not quite as friendly a relationship with the directors and officers and the internal folks from the company. Little interested in thinking about whether or not the restructuring officer regime is going to allow different distribution options to come in, thinking about the point where you might have a sale of part of an entity, things like that, and wondering if you had a jurisdiction that had a distribution scheme that differs from the Cayman law. I mean, is this something that you'll be able to recognize, kind of an end around to the Cayman version of model law, recognizing that, or do you think we're still stuck with the Cayman distribution scheme no matter what?
Well, the purpose of the restructuring regime is hopefully to avoid a sort of statutory liquidation regime in terms of an order of the way in which proceeds are applied. I mean, there's no reason why we can't have schemes of arrangement here agreed with various different types of creditors. Some may be higher than others on the pecking order, and there's no reason why different deals can't be done with different creditors. And why, for example, that in certain circumstances, shareholders or certainly management that might hold shares might be cut in for a little bit of the action in order to to continue in their role as management. There's absolutely no reason why we can't do that. The idea of the restructuring regime is the restructuring officer regime is to be as as flexible as possible, and certainly the courts have recognised that here as well.
Chris already seems more nimble than he did before. I can see that flexibility coming through, even in the posture.
Well, it was always because the restructurings were done under the guise of a provisional liquidation. So everybody always retreated back to, well, what's the order of priority in a provisional liquidation, whereas the focus in the restructuring is much more on finding a plan of reorganization or a scheme of arrangement, whichever you want to call it, and being more flexible in that regard.
So do you feel there's anything else that needs refining about the scheme? Is there anything that you would still like to change or differ?
I mean, just going from the experience that I had, I mean, I think the Rockley case was almost the kind of perfect case study. It was a company that had it needed to deleverage its working capital, it needed to protect its staff and its IP, it needed to introduce fresh working capital. And it, an introduction of a liquidation petition, like I said, would have been catastrophic. So the process just worked so well for us that from that experience, there was nothing obvious to me where I thought, okay, there's some kinks still to be worked out. Like I'm sure, as 3 or 4 or 5 more go through, we'll start to see things. Okay, we could tweak a little bit here, tweak a little bit there, but to Chip's point, I think this is so much more nimble than we've been able to be before, and the options are not infinite, but they're far more wide ranging. So it does feel like you have real scope to kind of look at the situation, work with all of the stakeholders, company and creditor, shareholder, whatever it may be, and figure out what is the best plan. You're not staring down the kind of the end of a gun of there's a winding up petition file, the clock is ticking, let's figure out what we can right now. So my experience was that it really does work, but like I said, I'm sure there'll be tweaks as we move forward with it.
Yes.
One issue that might become interesting in the future is, as I mentioned before, you when you apply for a appointment of a restructuring officer, you get the benefit of the moratorium immediately. The fact is that you don't actually have your hearing as to whether the restructuring officer is going to be appointed for up to 21 days, and that's what's mandated in the rules. And in the first two cases, the court has heard the application on the 21st day. I think what will be interesting is there is provision in the restructuring officer regime for an interim, or effectively an urgent restructuring officer to be appointed. That yet hasn't taken off as a necessarily as a concept yet. I don't know whether the cases have demanded it, but it'll be interesting to see the way in which the courts apply apply the law in terms of when an interim restructuring officer is going to be appointed. When you really need one within a matter of days rather than 21 days.
Right.
So
sorry, Chip, go on.
Sure. So what I was going to do is flip the table for a second. We've been going at it from the idea that the restructuring officer is a great idea, and how do we get it done? What if we're on the creditor's side? How the moratorium, certainly stays things. What would if you didn't have a friendly creditor base? What would the tactic be? How would we advise creditors to try to head it off for their own interests? Is it simply the only hat they have to hang on is trying to prove that you're not currently unable to pay debts or likely to be unable to pay debts, or is there any other creditor defensive strategy that you'd advise?
Well, I mean, yes, there's that. There's the obviously challenging the restructuring officer and saying it's not being brought in good faith or whatever it may be, or that the books are incorrect and it's not, they don't have a case of insolvency, something along those lines. I mean, the other obvious one is attacking the company in other jurisdictions where they have assets that aren't currently protected by the bankruptcy regime. I mean, the restructuring officer regime is expressed in Cayman, or as a matter of Cayman Islands law, to be a worldwide moratorium in place. But we all know in practice that whether or not that happens or not is very much a question of comity for other courts, and depending on where those assets lie.
So Chip, coming back to you, I mean, you've just done this trip to the ends of the earth that I'm not at all jealous about, like Australia and Singapore and so on. What sort of reaction do you get? Because obviously you were talking about this over there. How were people perceiving it? What did they actually know enough about it? Were they able? Did they understand it? Did they understand the purposes of it?
Yeah, so both Singapore and Australia are pretty sophisticated insolvency type places, where they've had both the traditional winding up type world for a while, and they've also had their efforts at restructuring regimes, whether they follow the Chapter 11 regime or sort of head off on their own. So I think it's super well received. Really interested in what kind of clever things that they can do to take advantage of it, or represent their client to the extent that it's not an advantage to have a restructuring officer introduced. So I think especially in Australia, where, like I say, they seem like they're a little ahead of the curve right now and running into insolvency problems. They're having a lot of construction insolvencies.
Right.
Many of the folks that I was meeting with had to juggle around recent appointments, clients calling because they were either going insolvent or they were creditors of people who were in trouble, and so they were keenly interested. So many of these, as I mentioned earlier, these hedge funds that have Asian Pacific money end up going through the Caribbean, somewhere, whether it's Cayman or the BVI's, and so seeing this was interesting to them. The defensive tactic, being able to stay off the winding up petition, was interesting to them. Again, always wanting to see if they can find that big cooperative thing that's not headed off by one creditor group in a jurisdiction. So I think a lot of interest, lots more to figure out. As you've mentioned, as we go through the next couple of years and have more of these things, there will probably be some nuances that work their way out. And I think in general, from the model law jurisdictions, this ability to, kind of do the end around to make Cayman kind of like a model law jurisdiction where you can bring in some of these things from other places. It's really, really a big game changer. It really adds a lot to the strategy. And I think you guys are going to get a lot of phone calls.
So
That's the plan.
so with new things, it's always the same with new stuff. People always sit back and they wait. They like to see others do it first. Do you think that people are waiting before they try this? They want to see some cases go through. They want to see people like Chris and Rupert have to go through the mill first before they try it. Do you think that's the case? What do you guys think, Chris?
Yeah, absolutely, for sure. I mean, I know that we had some reticence, and there was certainly, a job in educating the people who were involved in our case that, whilst it's technically a completely separate and new regime, there are huge similarities to what's gone beforehand. So, you can't technically take the case studies or the case law that's developed over the years in the PLs, but, we certainly expected that a lot of that would follow through and be an accurate representation of how things would play out in the restructuring officer regime. And they were, but I think it's only human nature to, just be not skeptical, but be concerned. I mean, these boards or creditors, they're taking, from their perspective, it's a big risk to bring somebody external in and put them in charge of the company and, put your, the fate of your recovery in somebody else's hands. So, I think whilst, we're all, certainly sitting here today, we know that it's a very powerful tool, and I think it's going to be really helpful for us, going forward. But, I think you need to see a few more go through the process successfully before everyone else kind of buys into that. But, I think it's only a matter of time. Certainly from practitioners in Cayman, we are going to try to use them as much as possible. So it shouldn't take too long, I think, for that kind of body of casework to build up.
What do you think, Rupert? Do you agree?
Yeah, absolutely. I mean, I think it's a bit more about becoming comfortable with the whole process. As Chris said, there's always an education process for clients on a new regime. In this one, of course, as I've sort of been saying, that the moratorium at the start matches well with the Chapter 11. So that's something that US practitioners and US based folk certainly appreciate and understand. They appreciate. I mean, some of them have been through the old PL process, right, where there was a provisional liquidator supervising a board previously. So in that regard, that hasn't changed significantly. And so whilst there's an education process, there'll be more to come, I think. And obviously, we're quite excited about that prospect.
Good. So, Chip, to finish off, I mean, do you feel that people are missing out by not taking advantage of this and not sort of knocking on the door and wanting to get going with it straight away?
So I don't know that they're missing out, so they don't want to knock on the door. I was a little interested that I was the flag bearer in Asia for this. So many people that hadn't heard about it, didn't know about it, didn't pay attention to it. Apparently don't read their insole magazines, and there's been a lot of literature that's gone out. So I don't know that it's so much that folks aren't intentionally doing it. I think there's a lot of opportunity to educate people. You also get into where English is a second, third, or fifth language for folks too. And so as you start interacting with China and different parts of the Asia Pacific, I think there's some things lost in translation, some opportunity there to help. There's so much money went out with the Belt and Road Initiative that's now being restructured or insolvent or having to be having to be recovered along the way. That I think those are some examples of just a continued audience that probably needs to hear about it. If I was a marketing person like you, Becca, I'd say probably they need to hear it 7 times before it sinks in.
At least.
At least. And so
like we need to do some traveling.
Yeah,
we'll join you on the next jolly.
November for sure. But yeah, but I think that's it though. I think things like this are really helpful. I think having you guys who've actually been through it a bit, is helpful to talk about how it goes on. And I don't doubt that it's going to become very popular and perhaps influenced if we are fortunate enough to go off the worldwide insolvency cliff soon. That might drive it faster.
Well, it's been thank you so much, guys, for your time today. I mean, it's been really interesting. So thank you, Chip, Chris, and Rupert. If people want to get hold of you, where's the best place? Would it be LinkedIn? Chris, where should people get hold of you if they want to talk to you more about this?
Oh, I mean, LinkedIn exists, but it's been a while since I checked it out. So I think just the Alvarez and Marsal website has all of our contact details up there.
Excellent. What about you, Rupert?
As with me, the Walker's website is the best place to find me. We have biographies and lists of experience and all that sort of thing on there. So absolutely through there.
We need to sharpen our tech pencils.
Yeah.
And Chip, where can they find you?
LinkedIn, the Raymond website. Chris and I will be at the swim up bar at the Westin soon too, so you can catch us there if need be.
Yeah,
every Tuesday afternoon.
I'll see you in half an hour. Yeah. Well, thank you so much, guys. Have a really great day.
Thank you, Rebecca.
Thanks,
you too.
Rebecca. Cheers, Chip.
Thanks, Chip.
Thank you.